The Rochester City School District appeals from an amended judgment entered upon a special jury verdict awarding plaintiff $1 million for the conscious pain and suffering of her daughter, who was stabbed to death by another student on school grounds. The jury apportioned fault between RCSD and the assailant, finding that plaintiff's decedent was not at fault. We agree with RCSD that the award of $1 million for conscious pain and suffering deviates materially from what would be reasonable compensation. Within the 5 minutes of being stabbed, plaintiff's decedent collapsed and lost consciousness. Less than 1 hour later, she was pronounced dead. In our view, an award of $300,000 for decedent's conscious pain and suffering is the maximum amount the jury could have awarded as a matter of law. We modify the amended judgment, therefore, by vacating the award of damages for conscious pain and suffering, and we grant a new trial on damages for conscious pain and suffering only, unless plaintiff, within 20 days of service of a copy of the order of this court with notice of entry, stipulates to reduce the award of damages for conscious pain and suffering to $300,000, in which event the amended judgment is modified accordingly, and as modified, affirmed. None of RCSD's remaining contentions is preserved for our review. RCSD contends that Supreme Court erred in failing to instruct the jury on implied assumption of risk. RCSD, however, did not request that instruction, join in a co-defendant's request for that instruction, or object to the court's failure to give that instruction. RCSD further contends that the verdict finding no contributory negligence on the part of the plaintiff's decedent is against the weight of the evidence, and that the court therefore erred in denying its motion to set aside the verdict, see 4404A. RCSD, however, did not move to set aside the verdict on that ground. See Nitsky v. Loveland, 188, Appellate Division 2nd, 1058. RCSD, however, did not move for a directed verdict on that issue or otherwise object to the submission of that issue to the jury, see 4017. Rather, RCSD sought a directed verdict dismissing the complaint on the ground that the assailant did not have a history of violence. That motion was properly denied by the court based on testimony that RCSD was warned of the impending fight against shortly before it occurred. RCSD contends that it was entitled during deliberations to review the partially completed special verdict sheet before it was returned to the jury to be completed. RCSD, however, never made such a request or objected to the action taken by the court. It is hereby ordered that the amended judgment so appealed from be, and the same hereby is unanimously modified on the law by vacating the award of damages for conscious pain and suffering, and as modified, the amended judgment is affirmed without costs, and a new trial is granted on damages or conscious pain and suffering only unless plaintiff, within 20 days of service of a copy of this order of this court with notice of entry, stipulate to reduce the award of damages for conscious pain and suffering to $300,000, in which event the amended judgment is modified accordingly, and as modified, the amended judgment is affirmed with costs. 140.